I'd like to call the committee of the whole for Village of Cary for Tuesday, September 4th, 2018 to order with roll call, please.
Weinhammer?
Yes.
Cavelli?
Here.
Kostler?
Here.
McAlpin?
Here.
Betts?
Here.
And once again, before we do the pledge, just a voice vote to allow anybody here who would like to address the committee of the whole before we get started. Anybody have any comments for the committee? We'll go ahead and close public comments. First item of discussion is fireworks. Chief Finland.
All right, good evening. Everything worked fine, so we're going to start relatively quickly here. First thing that I'm going to pop up here is a quote by John Adams. And basically, he indicates that during Independence Day, we should celebrate with guns, bells, bonfires, and illuminations. So that was in an article while I was doing the research for this on an internet-based magazine called Vox, V-O-X. And it's fitting because we just passed a proclamation for Constitution Week. So what we're going to talk about here is our authority as a municipality to regulate fireworks, our current ordinance, the current statute and some proposed legislation, the risks that are related to the use of fireworks, our calls for service related to fireworks and noise, the community standard that you'll be required to identify, and then options that we'll have as it relates to moving forward in regulating fireworks. So our first thing, and I'm going to invite Mr. Euler to chime in whenever he feels necessary, as a lot of this has to do with the authority of the municipality to regulate certain things. So the first thing we're going to talk about is our authority to regulate fireworks, and as you can see in this state statute, the municipality can regulate and prevent the use of fireworks and other things, and that's all within their authority. The other thing that, this is the, I believe it's the Fireworks Act that relates to the ability to regulate, restrain, prohibit the use of fireworks, firecrackers, torpedoes, Roman candles, skyrockets, and other pyrotechnic displays within their corporate limits. I think this more relates to the issuance of permits and displays that are for the public. I believe that that's what this talks about. But so far, what we've not seen in the regulations are the ability to regulate possession. There's, and I think that's important because when we look at our ordinance and ordinances of some neighboring communities, it becomes important as it relates to the construction of those ordinances. This is another public safety statute related to the possession, sale, and use of fireworks, and this is related to the Pyrotechnic Use Act, I believe. And this now starts to address possession of certain fireworks that are prohibited in the state of Illinois, and that the county boards and incorporated towns shall have power to adopt reasonable rules and regulations for granting of permits for pyrotechnic and consumer displays. And then finally, municipality may by ordinance prohibit the use and sale of sparklers on public property. That'll become important when we start talking about injuries that relate to the use of fireworks and similar items. Because what you're going to see is that more people are hurt by sparklers than they are by fireworks. So in our current ordinance, it indicates that it's unlawful to store any fireworks within the village, and it's unlawful to offer them for sale or fireworks or pyrotechnics in the village. They classify fireworks in two ways. One is a federal classification. I think it's 1.8G or something similar like that. And there's, it's related to the commercial use that you might see at Lions Park. And then there's other Class C fireworks that are also prohibited in the state of Illinois, but they're not the large fireworks, because when we start talking about injuries, you'll find that those mortar-type fireworks also relate to serious injuries. Finally, our penalty provision for fireworks as it relates to our current ordinance is related or restricted to between $50 and $750. There's also something I want you to keep in the back of your mind when we start talking about options and what we're going to do moving forward. And we have a noise ordinance, and it's unlawful to make or cause to be made any noise or sounds of such volume or nature as to cause annoyance to a reasonable person. The reasonable person is not a hard person to find, right? Because that's something that is kind of sometimes hard to define. And then also, when we start talking about noise, there's no hours defined or identified in the noise ordinance as it relates to offenses against the public peace, but we do have hours identified in regards to restriction of the production of noise in our building ordinance. And for this, I think that it's 2 or 3 areas that you'll find that in our code, and this is just one of them. And it indicates that you can't make annoying noises during construction activities between the hours of 8 p.m. to 7 a.m. This is the ordinance for the Village of Algonquin, and you'll note that it's very similar in construction to the ordinance that we have, and that it restricts the sale of fireworks and then the use, explosion, or of fireworks, but you don't see anything in there related to possession. So it's constructed very similarly, as is the City of Crystal Lake's ordinance in regards to the offer for sale and the storage. In the Village of Lake in the Hills, there is a prohibition against possession. And I don't know, this is where I'm going to have to defer to the knowledge of our attorney, but the Village of Lake in the Hills is a home rule unit. So by population, they're a home rule unit, and I don't know if they can expand their abilities to regulate to possession. So I don't know if that means anything as it relates to the construction of their ordinance.
They can, as a home rule unit, expand their authority in this area. This is not an area that is preempted by state law, but if a non-home rule unit, like the Village of Cary, wants to regulate under the existing 2 statutes that govern the regulation of fireworks, you could regulate possession as well, if you choose to.
Okay. So that's another option we'll talk about when we talk about moving forward. There's a couple other things that I wanted to bring to your attention when we talk about this, and that's House Bill 5928. That was proposed by Representative Barbara Wheeler from McHenry County, and it was an initiative to make the possession, use, and sale of consumer fireworks. And again, we designate commercial fireworks and consumer fireworks differently, and that there'd be a age limit in regards to the use, and then there were some parameters related to their use, that is the fireworks, within 200 feet of a structure, person, or vehicle, and they couldn't use, the use of those fireworks couldn't violate any local ordinance. And then there's provisions in regards to licensing of retailers, associated costs for licensing, and then also addresses the disposal of seized fireworks. It's a little bit different when I started reading it, because now when you make the fireworks legal, now they potentially could be returned back to their, whoever possessed them previously. And I just put in here a reference to a Chicago Tribune article related to maybe some of the motivations of surrounding states as it relates to why 11 states in the past, I think since 2011, have repealed their restriction on fireworks. and some are indicating that it may be revenue generated as it relates to the potential for, to earn $9.3 million in Pennsylvania was one of the states that recently made the use and possession of fireworks legal, and they're looking at earning $9.3 million in 2018 by imposing a 12% sales tax on those fireworks. I found another one while I was doing the research, House Bill, and that is a tax, it amends various tax acts. It was introduced by David A. Welters from Morris, and it would impose a 12% use tax on fireworks. I didn't understand why they prohibited the use of fireworks in vehicles. I would never use fireworks in a vehicle, so I don't know why it needs to be prohibited. And then anyone that uses fireworks had to be 18 years of age. Any revenue generated from this particular House bill would have 50% of the revenue deposited into a fire prevention fund. And this was assigned to the Rules Committee, where the legislation proposed by Representative Wheeler has not been assigned to any committee. It's just been enrolled, not taken any action on. Here's an article, a chart from a Daily Herald article, where it says that fireworks injuries are on the rise. Interestingly enough, they cite Indiana and Wisconsin. And although it looks like on these, this chart that Illinois far surpasses the injuries experienced to Wisconsin and Indiana, when you start looking at injury at a rate per 100,000, Illinois has a rate per 100,000 injury for fireworks use of 2.7. I left out a 0 on that one. I feel bad about that. And then Wisconsin had a 1.8 injury rate per 100,000. And I had to do some calculation as it relates to Indiana. And when you take their total population and the injuries that were reported, you come up with about a 3.5%. 3.5 per 100,000 injury rate in Indiana. You might ask yourself, because I just did, so I had to look it up, unintentional injuries that are experienced by people at large, it's 26.3 per 100,000. So that's 2016 data. So some of the other, in 2015, there was a similar provision that was put forward, and the Illinois Fire Safety Alliance mobilized against the legalization of fireworks at that time. So I put a screenshot of the information related to that, and also there's an alliance to stop consumer fireworks, and it lists a number of different agencies or organizations that agree with that as part of the fire service information as it relates to their position on fireworks. This is from the Office of the Illinois State Fire Marshal, and this is 2017 data. When you look at this data, and we're going to talk about this very briefly when I move forward, that 2/3 of all injuries are experienced within that 30-day period right around July 4th. So when you look in Illinois, 2017, there was one reported fatality and 204, injuries during that 30-day period. And there's a chart there that indicates where the injuries occur. Most of the time, it's the hands and head, face, and ears. This is just a table that indicates fireworks injuries per 100,000, and it's from the Consumer Product Safety Commission, and indicated in 2016 that the rate per 100,000 was 3.4 injuries. Now we start talking about why are we looking at this? Are we looking at this because we're safety related, or are we looking at it because it's a noise issue? And if you look at the data that's provided by the Consumer Product Safety Commission as it relates to injuries that occurred within that 30-day window in 2016, you'll note that sparklers tend to have a higher rate than small fireworks. So I told you you had the ability to regulate sparklers on public property. So, that kind of stuck out with me when I started looking at the data, saying, okay, that's something that, you might want to be looking at as well, because if it's a safety issue, then you have to look at those type of items as well. Again, this is just another chart as it relates to device and ages, and you'll note that the sparklers have a high number of injuries in the area of 0 to 4 years of age, and no doubt it's related to someone maybe supervising or not supervising a child and them maybe grabbing a sparkler that's lit. These are the percentage of injuries by age group, and you'll note that if you take the group 20 years of age and older, that's by far the majority of people that experience injuries as it relates to these fireworks. And again, just kind of reinforces the regions of bodies that are injured as it relates to the use of fireworks. And hands and fingers and head, face, and ears make up the majority of those injuries. This is from an article by the Insurance Journal. It was written July 2nd, 2018. It's reinforcing things that I already said, that 2/3 of all fireworks-related injuries occur between mid-June and mid-July, that the consumers spend between $885 million on fireworks last year, and they expected a $60 million increase this year. 11 states since 2011 have enacted or lifted restrictions on the sale of certain consumer fireworks. And again, the cause of injury, you'll see that sparklers are 14%, reloadable shells 12%, fireworks 10%, and then bottle rockets and the homemade or altered fireworks were 3% of those injuries. By the way, the bullet that I didn't talk about was that in Iowa, when they repealed their restrictions on fireworks, a number of municipalities then started looking at their local ordinances or local laws as it relates to regulating fireworks, in regards to that initiative. This is, again, your responsibility as it relates to who has to identify a community standard and where that threshold is and tolerance. I didn't take this, I found it. But I will tell you that having had a daughter that was on color guard for 4 years and having had attended a majority of the home football games, that there's always fireworks going off, not in the village of Cary, but outside the village of Cary as it relates to the football game. So again, there's some tolerance to fireworks in certain circumstances. These are our calls for service for the last 3 years, 2015, 2016, 2017. You'll note that the fireworks complaints that are in red on the bar chart range between 40 and 50 a year. And what you'll really see is that there's a significant increase in calls for service related to noise complaints. And I can't answer why. I can speculate. It would seem that we have less tolerance in regards to noise generation now than maybe we had before. So, given all that information that I did relatively quickly, you have a couple of different options. You can do nothing. I read a book called The Essence of Decision. It was about the Cuban Missile Crisis, and that was one of their options, so that's one of yours. You can amend the current ordinance, and that is that you can look at what are you trying to control. Are you trying to control safety or address safety? Are we trying to control noise generation? If it's noise generation, as a time of day, are we trying to regulate category of devices? And are there going to be enhanced penalties? And we have another issue is there's a piece of legislation out there that could potentially make these devices or items legal. So it might be something that you want to consider down the road. I will tell you that, in that legislation, you saw some of those restrictions, and it was over 18 years of age for the use. And then in certain circumstances, they wouldn't allow, or it would be illegal to use those fireworks, and that was within 200 feet of a structure and if it was in violation of any municipal ordinance. So I would be open to any questions you have right now.
Yeah, Chief, I have a question. Could you go back to the chart, that one? So are you saying that the fireworks versus noise complaints, the firework complaints aren't about noise, they're just about fireworks, or they are noise?
No, okay, it's a category or a nature call. So when the call is received and someone complains about fireworks, that's how it's categorized. So we would call that a nature code, and noise would just be general noise, but if it's specific to fireworks, they'll make that a fireworks nature call.
Gotcha.
So could there be noise complaints that are fireworks complaints? There can, but it's really up to the dispatcher to make that determination and to use that nature code, and that's how I'm grabbing this information.
Any other questions?
I don't have any questions, just for discussion purposes. I don't think anybody has a problem with fireworks going off after, football games and on the 4th of July and things like that. I think from what I've heard is, at 11 p.m. or 1 a.m. and they're going off for more than an hour. In those situations, I'm not talking about football games and things like that.
And I'll tell you that I was a police officer for a long time, and if there was a municipal display, it was guaranteed that after that municipal display for a couple hours afterward, people would always have some type of activity related to fireworks. And if you were working that midnight shift, you were happy if it rained, because then everyone went inside. So I think, if we're talking about noise, then, and we're talking about maybe hours that we're willing to tolerate this noise, then that might be the way you want to go, versus trying to regulate the devices or possession of the fireworks. It's really, the board's decision.
If I could just ask you to pause for, go ahead, Kim. Go ahead.
I agree. I think we should look more regulate noise. I think that's the biggest complaint. I don't think people are complaining that people have fireworks. It's the noise that fireworks are creating, especially when it's those later times of the night.
Okay. We have a resident here, Mary Hall, if you'd like to come up and this is near and dear to you. And she, in front of the dais here, you have a list or a little thing that she had submitted. So I've met with Mary at quite length about these things. So I'd like to just have you kind of address the board or the committee where you feel you are right now.
Hi, good evening. Thank you for allowing me to come to speak to you. I had given Jake sent him an email.
Yep, we've got it right here, Marion. I passed it out to the village board.
There, okay.
Yep.
I didn't see the sign from back there.
Yeah.
That, from Des Moines, the Register, and that's last year and this year, is fairly informative. And the people who did pass the ordinance were really distressed by the fact that it wasn't enforced by the police. And I have that same feeling of frustration because I've called 5 times. The chief has some data and stats on injury, and that wasn't, oddly enough, the primary reason that I'm calling. What I'm calling about is not the physical injury you get, like burnt finger or even the eye damage, the injuries that I'm aware of and many of you may be aware of. What I'm concerned about is the mental and emotional distress caused by sudden, unnecessary, highly threatening, explosive noise. You don't know who I am. I just moved here. I have a history of over 40 years as a therapist, and among my clients were a number of men from special forces, a number of kids from Bosnia with PTSD, and a number of kids with PTSD. These noises, and special needs children as well, autism, learning disorders, behavior disorders, are all upset by the noise that fireworks makes. And I think their needs should be looked at. If I in my yard decide to make whoopee and make fireworks, like my neighbor on the corner that I made a call about and nothing happened, the point is that I impacted from my yard the people within at least a quarter of a mile from my house. And here, since our houses are on acreage, that may not be any more than 200 or 250 homes. That's still too many homes. There's a policeman who lives around the corner from me whose baby got up, and he got up because of fireworks that were going on, like Jennifer said, for over an hour and at an inappropriate time, between 11 and 12:30 or 1. Now, this may be disconcerting if you like fireworks. It's an ego issue to me to do that. It's a primitive noise-making pleasure that I have worked with behavior disordered children that they get off on, that kind of behavior. So to me, it's not normal or rational, considerate human being behavior. All right, so I had a wee presentation. If you wanted a copy of this, Jake can, and I'll make arrangements with him to give it to you. But these are the points that I really wanted to make tonight here, okay? First of all, fireworks pollute the air. You can tell by the smell and the rancor. They're not celebratory then. They're not about celebration at all. They're about polluting the air and making personal noise. They also pollute the earth, not just the detritus and the windfall from the stuff that blows up has to come down. It's the point of leaving a mess behind, like bombshells. They're not minefields because hopefully they're no longer explosive. Although I did read a story just today on the internet about someone who buried fireworks to save them for Christmas, and they exploded. They exploded in his burying place or in his hiding place. So, all right, I want to also remind you that they are created by toxins. And I found out when I lived in St. Louis, I was working with the JCs for their 4th of July celebration, and I talked to the fireworks guys, guys on a barge on the river, and I found out how many toxins and really dangerous chemicals and carcinogens were involved in fireworks displays. This is big scale. I'm talking about, though, my concern is mostly the people in private homes and private settings here in Cary who disrupt the entire environment. They may not be responsible for that much carcinogen or that much pollution. It's the mental and emotional impact of sudden, unexpected, threatening noise on each of us. On me, I'm from the inner city. I'm from here. I got noise. I got shootings in the alley. I got rapes in behind my house. I understand that. The point is that these people don't have to do that, and we are not enforcing the law to prevent them from doing it. We are not enforcing the law to prevent one person, if I wanted to do it in my yard, from impacting 200 or more homes, families, and people, more than 200 people, with my desire to show off, okay? That's really from the therapeutic point of view. That's what this behavior means. It's an egotistical and egocentric behavior that doesn't have a regard for the people who have to suffer the consequences. That's really important to be aware of. I came here for the peace and quiet, and I'm not getting it. It's not here. Because these fireworks have been intermittent since I moved here. And it started in actually shortly after Christmas. It was New Year's, and then a Memorial Day, and that went on for 2 weeks, and then 4th of July, and that went on another 2 or 3 weeks. All right, a couple of more points. As I said, fireworks to me, I'm not talking about the display, like if we were to do something in Algonquin or downtown and it's a safe place. I'm talking about individuals who are allowed to and not penalized for shooting off or creating the distress and the noise from fireworks, okay? They sacrifice the peace, safety, and well-being of those of us who are victimized by these ongoing, powerful, and intrusive sounds. I told you already about the distance, I would say, or the coverage of the noises of these fireworks. And all of these families are disrupted. They create a very strong negative impact on pets. Now, this last time really upset me personally because my dog had just come home from emergency surgery, and she's a little wired to begin with, and she was meant to be sleeping, and she couldn't because she was very afraid of the fireworks and didn't sleep for many, many hours. Even though I gave her melatonin, didn't help. And I will tell you, as a member of the board member of the Humane Society, when I did live here before, I adopted 2 dogs that had run away because they were so afraid and distressed by loud noises and fireworks. And these runaways occur primarily after firework events or holidays have occurred. They also cause distress to children and small children. Like I said, policeman's baby was awakened by it, and they present a major fire risk in a drier wooded area. And although we've had plenty of rain now, we have not had that much during the summer. So the bottom line is that the noise and the disturbance created by fireworks does not end with Fred, who thinks he's a big shot because he can either show off to his family, his buddies, or his children how to make big noises. That's not where the experience ends. It impacts everyone all around. It isn't something you do covertly in your basement and no one knows about. It is something that's done outside and disturbs many, many people. And it's better to me and safer. I like fireworks too, but Grant Park, downtown city displays, that's where I'm looking for fun and the joy and the beauty of fireworks. And that's where they belong. Okay? All right, they're dangerous to me. If you want a copy of whatever I have here, just ask Jake and I'll make sure that you get it. Do you wanted to ask me any question? I can answer for you.
Any questions for Mary?
No.
Thank you.
Thank you for
Appreciate your
coming.
passion.
Yes.
I'd like to just address one issue, and I meant to do it when I was doing my presentation, but the other part of this equation is that when someone does make a complaint, that there has to be a person willing, because they have to be that reasonable person as it relates to the complainant for, the complaint related to noise, if it's a noise complaint, because especially when it becomes like a disorderly conduct issue, police officers tend to not be able to be alarmed and disturbed, right? It has to be somebody that is being affected, and that's the other part of this, is that sometimes we'll get anonymous complaints that there's fireworks in the area. And it would be difficult to prosecute unless the police officer sees it, to bring forth some type of action related to enforcement without the complainant saying that it came from a certain area. And being willing to come to either administrative adjudication hearing, or in the worst case scenario, an enforcement of the state statute, which is a Class A misdemeanor, which requires us to take someone into custody, fingerprint them, because then we have to report that to the state. So that's part of the processing for the state charge.
I think maybe part of it might need to be public education, or just when somebody places a call, then to let the person who's placing the call know that something can't actually be done unless they're willing to sign a complaint or something like that. Because I think that possibly the general public may think when they're calling the police and they hang up that phone that you're going to handle it and that they don't need to do anything else. And when you're saying to them, do you want to be seen? They're just saying probably no. They don't realize that they actually need to do one more step to go ahead and have to have possibly a solution.
Yeah, and very often it's more of a matter of routine in terms of the way that the call is processed. The telecommunicator will always ask, do you want to be seen by a police officer? What do you want? What do you want done? And we'll get something called no complaints to be signed or no complainant to be seen.
What I'm saying is that if you're telling somebody maybe from the general public, do you want to be, or you're asking, do you want to be seen? And they say no, maybe again, they're thinking that you're going to solve the problem or you're going to handle it, that they don't realize that they need to do that extra step and be seen in order to go ahead and have the complaint actually filed. I think in their head, possibly the general public is thinking, I made the call, you guys are going to follow up with it, and I can go back to bed.
Okay. That could be part of this.
Right. And in your experience, are your officers and yourself finding that when that does happen and you go out to an area where you think it's going on and you've maybe talked to people, is what people are looking for, I guess what it amounts to is what people are looking for, is it to stop, or are we looking for someone to get charged? I mean, I think that's where I think that's also a difficult in the sense that someone still may say, I still want you to do this, but I don't want the kid, fingerprinted and taken in.
Yeah,
type
and
of
I
thing.
would say the great majority of time, I'm sorry, I didn't mean to interrupt you, but the great majority of time, that is just, they just want it to stop.
Right.
And it's usually hit a threshold, right?
Right.
It's usually 11:30 or 12 or whatever that threshold is for that person that said, okay, enough in regards to the celebration. I would concur that that's been my experience.
So looking at the statistics that you have here with the firework calls for service versus noise, how do you think that we should handle the fireworks as a noise ordinance? And is it, obviously we've talked about people have to file a complaint if they're willing to file a complaint to proceed with this, because if they're not willing and we go out there to service and it's gone, how do we move forward with that?
Well, number one, as trustee Weinhammer indicates, that they have to express that they're willing to follow up on this, that they're going to provide some type of testimony at a hearing that says that they saw this happen. And then in regards to maybe the noise ordinance, you'd want to amend it for it to be specific in regards to the use of fireworks, and then we'll have to define what fireworks are, and then perhaps hours, if that's what we're looking at as well. But I think that there's at least 3 elements that we have to address, probably more, but I'm just saying that off the top of my head, and maybe Mr. Euler has more.
The only thing I would add is you are casting this in terms of the noise ordinance and the need to satisfy a standard regarding a certain
Annoyance.
level of disturbance. The fireworks themselves, firecrackers, are prohibited, period, their use. If it's a dud, you can't, it's illegal to use those in Illinois, for good or for bad. So the offense itself could be expanded to capture whether it involves excessive noise or not. The use of fireworks is prohibited, period.
Currently.
Currently, so unless that changes. So what we're looking at is some kind of local penalty, potentially in Cary, if someone is using these or making noise beyond a certain point at night, 11 o'clock at night, 11:30 at night, you could regulate that activity if you need to add that to a local regulation.
Okay.
Well, I think that we still need to do a little bit more homework on this. I'm curious to know, I did put in a call to Barb Wheeler's office. I have not heard back to see where she thinks this is going to go and talk to her one-on-one about what is your intent? What are you looking to accomplish here? So,
Can you go back to the options page too, Chief?
In my personal opinion, I don't know what the rest of the board thinks, but whatever we decide, I don't think that we should just wait on Barb Wheeler's, House bill being passed,
no, I'm not saying, I just wanted
Okay.
to know why is this important? Why is this something that she sees as value? Is it as a revenue generator? I could see that. I don't know. I just wanted to just kind of hear all these different things. So I just wanted to, obviously it's going to be buried in committees for quite some time. Nothing's going to happen over the next 6 months or so. But no, I'd just like to find out why.
Are there any thoughts from the village board here on the various options that have been proposed of where you'd like to direct staff to proceed on this?
Can I ask a question just to make sure? So we have something on the books, just by the sheer fact that the state of Illinois has
State
something,
statute.
correct? But we're also subject to that, are we not? Subject to that state statute? Okay.
But
So-
it's a Class A misdemeanor, so it's a pretty significant charge.
Yeah. So our options are then to lower that charge. We could say, hey, it's not a Class A misdemeanor. Is that what we're talking about? But yet we are doing something about it. I mean, I guess I'm trying to wrap my arms around what are we trying to accomplish here? Because I see 50 calls in a year, and I'm not saying that, I don't care if there's one, if someone's upset about it, I want to at least talk about it and see where we're at. But it doesn't seem like it's 50 calls does seem an awful lot to me, and maybe I'm just missing it. I'm just trying to figure out what we're doing to address this, and is there other ways we can address some things in combination with education, with, what we're trying to do?
Yeah, and I think you can make it a local ordinance charge. It does a couple things, right? If it's a Class A misdemeanor, it's proved beyond a reasonable doubt, the burden of proof is higher with a criminal charge. A local ordinance charge is a preponderance of the evidence. So 50.00001, likelihood that this occurred, we could get a finding liable. So the burden of proof changes with a local ordinance charge, number one. Number two, I think it really comes down to a deterrent, right? We're always looking for voluntary compliance and deterrent, and if we explain or transmit that this type of behavior is not acceptable after this period of time, I think then that expectation might be, not for everyone, I'm telling you, it's not going to be for everyone, but I think for the great majority of people, they would understand, okay, it's not tolerable after X, if that's the way you want to go. Or as Mr. Euler has indicated, de facto, the use of a firework is, you can't use it in Illinois right now. So the production of noise from a firework wouldn't, it'd be much easier to prove that if we had someone say, I saw him do it, or if I saw it.
I think it sounds like also from the resident that there's a frustration that she had to call several times and that it still didn't stop. And I don't know if those 5 times were all in one night or if it was over the course of time. But it sounds as though she's not getting any resolution from those 5 calls.
And in that particular instance, I had that call and it had NTCB at no complaint to be seen or no complaints to be signed. So when the police officer sees that and he responds, he is thinking that they don't want to go to court, but they want it to stop, and he'll go there. And if it's no longer occurring, then they'll say that it's unfounded or unable to be located. So I think it's a 2-part equation as it relates to, requirement by the complainant to stay involved with the police officer if the police officer doesn't see it occurring. Because if we see it occurring and we make it de facto that it's a firework, then that's easy. But I will also say that the information that Mrs. Hall, I'm sorry, I almost said Mrs. Park, I'm sorry about that, provided was that the same enforcement initiative in Iowa is being experienced there as it was here in relations to an unwillingness of the police officers to maybe enforce that particular ordinance or statute. So that comes back to your community standard. What am I going to tell them to do? And say this is what the threshold is going to be in regards to these type of complaints.
Any other comments on this? Well, I mean, moving forward, what type of resolution, Trustee Weinhammer brought this forward. What type of resolution are you looking for on this? Where do you want this to go next?
Well, at least for helping residents and from what I've heard, I would like, we already have a noise ordinance, correct, for the times of day and things like that?
Well, no times. There's no times on our noise ordinance. There's times as it relates to construction, but not for, as you can see, it's unlawful to make any noise or cause to be made any noise or sound of such a volume or such a nature as to cause annoyance to a reasonable person.
So somebody had said that, their neighbor blows a blowhorn several times a day. That's not covered under the ordinance.
No, it is if they're a reasonable person, right? Because that's the issue is if I mow my lawn and my lawnmower is loud and it annoys somebody, technically this would apply to that statute or this ordinance.
Does the noise have to be regulated by the decibel meter that
No,
you guys
let's
use?
not do that. I'm telling you, that doesn't work. I
I'm
had to
just
deal
trying to
with
get
that
some sort of a
before.
bearing here. I mean,
Yeah.
it seems like things are kind of all over the place. We want to make sure that our residents are living free and safe and they feel comfortable.
I'm
At
sorry, I
what
didn't mean to be
point- No,
that
I
way.
I get what you're saying.
But I've had to deal with this before in regards to the noise generated from an amusement park that was in a subdivision, and we had audio meter, I don't know how you say it, but we would have to be out there, and to be honest with you, we weren't doing it right as it relates to measuring it anyways, plus us conversing, that's 50 decibels. You know, that regular, normal conversation is 50 decibels. So now we're going to have a special piece of equipment that will have to monitor noise to determine the level that's generated. And although that is part, interestingly enough, of part of our building code as it relates to some noises generated by certain types of tools. But again, that's prolonged, and then there's an opportunity to capture that where a one-time incident would be very difficult, where Mr. Euler indicates correctly that fireworks are illegal and de facto, then the use of, and to generate noise would therefore be easy to say it was caused by the firework, you can't use it, therefore it was unreasonable.
Right.
I would have to make that argument.
Because by the time you would respond to a call for fireworks, they're gone anyway, they're done.
Sometimes.
Well, when you do respond and you do, let's say, I'm just throwing this out, I'm not picking on teenagers, I'm not saying anything, but let's say you found some young kids, I don't know, 12 to 18, whatever, 12 to 16, and you catch them and you tell them, do you find that if you talk to them, even if you don't see them doing it, but you assume these are the people that are doing it, do they adhere to this? Do they stop then? Or are you finding that you're going back and forth? I mean, I'm trying to get a handle on what the issues, because I certainly know, there's fireworks sometimes during the 4th of July at 12:30, 1 o'clock, and yeah, it wakes me up, and yeah, it's annoying. I understand. I'm just trying to figure out what's the best way to address it.
I think the majority of people will voluntarily comply with what we say at that time.
Okay.
But I can't guarantee future actions as it relates
Sure,
to
I understand.
that person. And generally, if you have to go back more than once after a police officer responds, I'm going to say generally, that's when some type of enforcement action would no doubt occur. We'd be more willing to initiate some type of enforcement action. When it comes to possession of fireworks, you know, from a property management standpoint, now you have fireworks that you're taking into the police department that you have to store, and then somewhere down the road, you're going to have to destroy. So, you know, that causes another concern from me in regards to management of evidence and property.
Also, and this is a little off on a tangent, but Lake County on their Facebook page the other week had, you know, if you see something, say something, you know, we're here to serve and protect. And I thought that was great. I feel that, you know, reading that, you know, maybe residents do feel that the police care. They want you to contact them with anything. And so from your standpoint, and I don't know, I'm not a police officer or anything like that, but you guys get calls all the time. But to the person that it's happening to, that's, you know, especially here tonight too, it's important to them. So
It's usually the single most important thing that's happening to them at that time.
yes, so I guess, you know, thinking about that post, you know, we're here to serve and protect. I'd like the people who are making the calls to feel that you are there for them.
Well, I think that that's true. I mean, you know, and really, the complainant dictates the course of action often when it comes to these type of things. So I don't think that that's something that we don't refuse as a police department to respond to any complaints. We go and investigate them all. So I don't think that, you know, the motivation or intent of the police department is to not do something. I think that if there's enough, you know, case in point is a domestic violence issue, there's going to be an arrest if there's cause to arrest somebody. It's just a matter of having, you know, a willing complainant and having a workable statute that isn't, you know, a Class A misdemeanor equates to DUI. It's the same level. So possession of fireworks and DUI are both Class A misdemeanors.
Okay, I'm going to go back to something that, you know, Trustee McAlpine had said. You know, she's talking about teenagers and, you know, she doesn't want, and I don't want, and I don't know how anybody else feels, them to, you know, first offense, get a, you know, Class A misdemeanor. And so maybe there are stages or steps that we could go through with, and making it a noise ordinance so that it does stop. Just, that's the end result that we want, is just for it to stop if it's bothering somebody and it's after a certain time and however else you guys want to look at it.
As Attorney Euler had mentioned, we can amend our local regulations here to cover it. That would be an option for the village board.
Yeah, what direction does the board want to go with this? Is this something I've mentioned, Kim Cavelli, who's on the phone, we haven't forgot about you, about concentrating more on the noise. I'm hearing about education. Is there something that we could do to better educate the community about things? Do we give like written warnings and keep it in a database on who you're citing these warnings to? In the event that something like this happens again, then they're cited with the misdemeanor to try to nip it in the bud? Or, I mean, I'm looking for just some sort of resolve here on the direction the board wants to go.
Yeah, to say, written warnings, really, we have a CAD system, a computer-aided dispatch system that compiles or stores that information. So even if we talk to somebody and we add notes to that call, we'll know that if it was generated at a certain location, that there's going to be prior incidents at that location. So regardless if we give them a written warning or we just have a CAD call, we're still going to have record of that. So that's a relatively easy thing to manage as it relates to information. And I would tell you that that's what we generate. The police department generates a lot of information. You know, we manage and store a lot of information.
Trustee Betts, do you have anything to add to this or any questions?
No.
What direction, Trustee Costler, I haven't heard much from you about this. Is there any comments that you have or direction you'd like to see go?
I'd like to think about it more, but I am open to pursuing some sort of our, change to our noise ordinance code that would be an hour restriction, something like that.
Trustee McAlpin, would that be suitable for you?
I'd like to, yeah, I'm not at a point that I'm ready to make a decision one way or another. I'm open to discussing it further, but I want to see if we have something that can work and we're just not applying it as effectively as we can, then I'd love to say, let's see if there's a more effective way to apply it.
I'll tell you right now, I don't think that we have, we could cite someone under a noise ordinance, but it's going to be a difficult issue to prove. And especially we would have to have, a complainant.
Trustee Cavelli, is there anything that you'd like to add to this or what you're looking for?
Just like I said before, I think maybe tightening up that noise ordinance. I think that would also help with like loud parties, other issues that might help with the police officer. But I just want to make sure the officer has the discretion to do what they feel is best when they get on the scene.
Okay. Is that suitable for you too, Trustee Weinhammer?
Yes, I guess I want to see like if there's going to be different steps involved. I agree with Kim with the discretion of the officer. However, if someone's placing, 5 calls to the same residence though, I would like to see something be done. Because 5 calls is a lot to the same residence.
Yeah, and I would tell you that, we have those type of ordinances for alarms, for perhaps tobacco possession by those under the age of 18, perhaps. I've seen those in ordinances. And now you have to go back to see if that individual's been warned X amount of times before you take that action. I would prefer to have it that, we identify that we're trying to control this activity and then give the officers on the scene the ability to make that decision whether or not to enact anything, especially in, consultation with the complainant.
But from what I'm hearing from the resident, the officer didn't take care of it if she had to call 5 times. I guess I'm frustrated for her. So I guess that I'm looking for something to be changed for anybody who is seeking quietness or trying to sleep at 2 a.m. and fireworks are going off and they're repeatedly called and nothing's still being done. That's basically what I'm looking for. I'm not looking for anybody to get a Class A misdemeanor. I'm looking for the noise to stop at unreasonable times.
Okay.
Basically compliance. Okay. Well, I think this is something I think that we still need to gather some additional information. We'll get with the chief about different options that we can come that would be, look back at the comments that we've been making here as a board. And then I'll bring it back at another meeting to kind of work it through and decide what the board wants to do, what the committee wants to do. Okay, is that okay? Thank you. Moving on to our next discussion is regarding the Cary Senior Living Community Room.
Thank you, Mayor. It's requested, most recent village board meeting, it was asked to have this item on the agenda just for discussion for potential agreement for the use of the community room. Just a little background on the project for both public and trustees that were not on the board at the time. Development was approved. The Cary Senior Living Development is a senior housing development, 62-unit apartment building that's being constructed presently on the corner of Feinberg Drive and Three Oaks Road. Received the zoning approvals back in 2016, and one of the conditions of approval at that time was for the developer to provide within the development community room or space that would be incorporated and utilized for future senior programming. The space was not designed to replace or should say it's not designed to replace the existing senior center in town. It was an additional space that was to be available for the general public or different organizations to utilize that could provide additional resources or locations for programming for seniors. The ordinance, entitlement ordinance that approved the project included the various conditions. And one of those was condition G, which is highlighted in the staff report, but you also have the ordinance attached to the report as well that specified specifically the conditions for that. Specifically, discussion was use agreement for the space would be executed with the village, park district, or other local organizations that could utilize the room for programming for local seniors. At this time, an agreement has not been implemented with a developer. Obviously, they've started construction on the project last week. The groundbreaking is programmed for this Thursday. They'll have about a year plus time period for construction before the building is ready for occupancy, but they're looking at end of next year, or end of next summer, I should say, for occupancy of the structure. We did have some preliminary discussions with the developer and the park district for the use of the space, specifically related to this provision. At the time, the park district indicated that they'd had more of a desire to utilize it similar to their existing fee structure that would align more with their existing policies as opposed to having a standalone agreement for the continued use or management of the room. So they would utilize the room more on a one-off basis if there's a need for providing some sort of program at this facility or outside of existing facilities that they had within the village. At their existing facility next door here or at the senior center as well. Staff has not had additional discussions with the developer on agreement with the village as well, but occasionally we do host certain events here at Village Hall for that are programmed or directed towards seniors, and staff would envision that a similar agreement to what the park district is looking at might work from the village's perspective to host those types of events at this facility there versus at Village Hall here. For comparison purposes, the community room in the approved plans is in the center portion of the building, near their main entrance to the structure. It's about the same size as this room here, the village boardroom. So it is incorporated into the plans and will be provided for the public there as well. But I'd be happy to answer any additional questions you may have regarding the project or the agreement requirement here, but presenting the information for discussion purposes this evening.
Trustee Costa, you brought this forward. What did you want to discuss?
I did, and I do have a lot of questions. I get first things first, Brian. Could you explain to the public here what approximately how much impact fees we gave up in exchange for this community room?
There were no, from a discussion standpoint, there was impact fees that we got as part of the project. One of the conditions was required, or that the board required of the project at the time was a $1,600 roughly per unit impact fee, in addition to the placement of the community room. But there was no other fee that was set in place at that point for impact fees.
I believe that based on the calculation that was being utilized here for comparison purposes for the PedCore development, it was around 250,000, I think, all in.
Right.
The village received, in replacement of the 250,000, it was 100,000 for payment to the village and then the community space.
Yeah, and that's what I was bringing up, because as well with the Three Oaks Senior Center, the village got $250,000 impact fee from that improved Three Oaks, the intersection there at Three Oaks and Silver Lake, right?
I don't know the exact number, but I'm pretty sure there were contributions by the developer for the intersection improvements.
Yeah. Anyway, that's not really what I'm arguing right now. What I'm trying to point out is something was given up in hopes of return for use of this community room. And what I am trying to ensure is that there are rules in place so that the public has access to this community room, because the village did give something up in exchange for the use of that room. So I'm concerned right now because we've had 2.5 years since the agreement was made, and there's been no progress on a formal agreement with Pearl as to the use of the room. I understand you have discussed it with the Park District, but I guess I'm actually thinking maybe this discussion should be postponed a little bit, because I would like a more firm stance, or maybe somebody from the Park District to appear and explain their thoughts on how this room could be used. I have trepidations about just giving it away and then allowing the Park District to collect fees on this room. It was not intended to be that. It was not intended to be a room where fees were collected, that the public had to pay a fee to use it. So I do have a lot of questions with this, and I think really what we need to do as a board is list them in priority. What do we have to figure out first? And in my opinion, what we have to figure out first is who's going to be managing that room. And we don't know that right now. It could be the Park District, it could be the Village of Cary, it could be the property management company for Pearl, but we need to figure that out. I think, some other things to think about is what rules are going to be in place as to how to divvy up the time sharing of that room. What's the priority order? Does the Park District get it whenever they want, or does a normal resident get to sign up and use that room when they want? So there's usage time issues there. Additionally, like I already said, the fees, I'm not in favor of charging residents to use this room when there's already been tax dollars given up for this developer to, build this community room for them. The next one, and maybe Village Council could help me with this, as far as what type of agreement we can make with Pearl, because the ordinance is pretty vague. I don't know how ironclad the agreement can be, and I would like some options from council as to what those would be. Also as to the duration of the agreement, and if something could be done in perpetuity, which I would think would be appropriate in this situation. And the last thing is enforcement. How are these rules going to be enforced? Not only after occupancy, but prior to occupancy. What is our leverage here to actually get an agreement? And maybe that's another question for Village Council. So I have just so many things that are going in my head over this whole issue that they need to be addressed. I'm not sure we can address them all tonight, but I would like, more input from the board, and maybe, maybe we can table this down the road and come up with a better method of solving these problems.
I agree, we're not ready to, it would have been nice to have some of these questions brought forth before this meeting. We thought that you just wanted to talk about the use of the room. You make some very valid points. And had we had that knowledge before tonight, we could have had some of these, we could have asked somebody from the Park District to be here, we could have asked somebody from Pearl to be here. I mean, these are some of the things that are legitimate concerns. It is my understanding that the management of the room is going to be done by the management company that Pearl has hired to manage the building. The intent of this room was not to be used by ordinary residents. It was to be used by senior programming, not only the Park District, but the various seniors organizations that are out there. It was going to be made for their use. And, you know, if we want to talk about allowing other options or, amending the agreement with Pearl about other things, then we need to discuss that. But the intent of the original agreement was that it was for additional senior programming to enhance the lives of our senior citizens, because we don't have a lot of things or places for them to go.
I wasn't on the board when this was talked about, but I thought I heard you guys talking about like scouts could use it or things like that, but maybe I'm.
I don't recall, this was specifically geared towards our seniors, because
Okay.
we do lack sufficient, adaptable, accessible space for seniors. And this space would accommodate that. It would accommodate, a larger group of seniors to participate in various activities, for their enjoyment and their socialization. So that was the intent of having this room. And when we made the decision as a board to move forward to have an additional facility for seniors, we still were able to capture $100,000. And in lieu of the $150,000 that we had gotten, the 250, then less the 150, we got a room that if we were to build, that would cost us probably about $1 million by the time it was all said and done. So we thought it was a good idea at that time. But Trustee Kosser brings up some very valid points, and these are some of the things that we should have addressed. We do have a list now, and we'll work on those situations. We do have some time. The construction is just going to be started. So happy to get back with this, and we can bring this back at another committee meeting, and we'll get some of these questions answered for you.
Yeah.
That meet your approval?
Sure.
Yeah, I agree that some of these things need to be addressed, and in the normal courses, we're moving forward, we want to have that addressed. I don't want us to wind up as a board in a situation like we got into with Pilates, where all of a sudden we didn't have firm enough information, so later on someone's getting charged and someone isn't, and we're getting in the middle of something. So I think that's great that we get some of these issues addressed and get it set up. And, my recollection was also that this was for seniors. We were concerned with the Krause Center. The building is in not a great state, and we wanted to make sure that we had, that we were addressing the needs of our seniors. So that was my recollection of everything, and I was on the board at the time.
Yeah, I just want to say one thing in closing. Mr. Berg, who is the principal of Pearl Development, was quoted, and this is what he said. "We take this very seriously," which he's referring to this community room. "This being the partnership with the village, this should be a win-win for everyone involved."
Right.
And I agree.
Yeah, I agree too. Is there any comments on this? One other thing before we move to executive session, Eric Morimoto had something he wanted to bring up.
Just one more department report. Due to the holiday, just a reminder from the holiday this weekend, garbage collection, which is normally Wednesday, is one day behind on Thursday. So it is part of our regular schedule already on the website. I just want to put that reminder out. Garbage pickup is Thursday.
Thanks, Eric.
Thank you, Eric. I will entertain a motion to adjourn into executive session, discuss litigation pending or imminent, Illinois 120/2C11.
So moved.
Second.
All in favor?
Aye.
Opposed? Thank you. We will adjourn into executive session.